Okay guys, so today we're going to be looking at Chapter 8, and there's about 3 or 4 things here that I really want to touch on. We're going to be looking at the trial process and this concept that we call the courtroom work group, and I'm going to start with the courtroom work group first. The concept of the courtroom work group was actually created by a man by the name of Abraham Blumberg, and he wrote an article called The Practice of Law as a Confidence Game. And I'm not going to really go into a whole lot about it, but basically what it says is this, that the courtroom consists of inner players and outside players. And these inner group basically consist of the district attorney, the defense attorney, and the judge. The easiest way to put what Blumberg says is that these three individuals really work together to produce their own type of justice. And what I mean by that is they're self-serving. The defense attorney works with the prosecutor because they have a relationship that has to be maintained past one particular case. It's a working relationship that also includes the judges. So these people are working together and they're conning the defendant, is essentially what Blumberg says here. So I want to look at these three individuals here. The district attorney, and you'll hear them called the solicitor, the prosecutor. In North Carolina, we call them the district attorney. They are really one of the most powerful people in the courtroom. The district attorney in North Carolina has prosecutorial discretion. They can decide whether or not to bring charges, and basically whatever they decide cannot be overruled. They are really the most powerful person in the courtroom itself because of that prosecutorial discretion. By the way, we also elect all of our district attorneys in the state of North Carolina. The assistant district attorneys are appointed by the district attorney. The second individual that I'm going to talk about is the judge. The easiest way to think about the judge is they're really the referee, especially in felony cases where we've got a jury that's trying the case. The jury is called the trier of fact. In felony cases, juries determine what is factual and what is not. The judge in this case is called a trier of law. And what that means is he simply makes sure that both sides play by the rules. That's all the judge does. Judges in the state of North Carolina are elected anywhere from 4 years up to 8 years, depending upon what level of court they sit on. Judges at the federal system are nominated by the president and confirmed by the Senate. They serve for life. Judges in the state of North Carolina can only serve until age 72. They have to mandatorily retire at age 72. And finally, I want to just mention what we call the defense attorneys. Now, there are 3 types of defense attorneys that we utilize here in North Carolina. The first type is what we call a privately retained attorney. If I get charged with a crime and I go out here and I spend my own money, hire my own defense attorney, that is a privately retained defense attorney. Let's say, however, that I am indigent, I am poor, I cannot afford my own. I can request that the state provide one for me. Now understand this, the state will provide a defense attorney for an indigent individual only if, number one, they prove that they're poor, and number two, only in cases to where the individual could be sentenced to jail or prison. If the only possible sentence is a fine, then the person does not have a right to an attorney. Also, if the person pleads guilty or is found guilty, then they have to reimburse the state for the use of that attorney. So that's how indigency works. To prove indigency, a person can claim that they need a defense attorney in court. The person then has to go up and fill out a form that discusses their financial situations, and the judge will typically make a determination at that point as to whether or not the person gets an attorney provided by the state. The final thing I want to mention is the trial process. In the trial process, and I'm talking about a jury process here, there are about 4 stages that have to happen. First thing is the jury selection. Now, one of the assignments I've got in this module is going to have you look up how we select jurors in the state of North Carolina. The jury selection process begins by having individuals in the community that come in and be part of a jury pool. Once we've got those individuals there, we go through a process that's called voir dire. And it's a Latin term, which essentially what it does is ensure jury fairness, ensure that we have a fair jury. Both sides, the prosecution and the defense, get to question potential jurors and can remove jurors that are biased or that are unfavorable. Now, these are challenges, and some of these challenges are limited, but I'm not going to go into that here. That's a section you'll cover in your court procedures and evidence class. Once we have a jury that's been selected, we move into what we call the opening statements. The opening statements in the trial process are a lot like your introductory paragraph in your paper. It tells where you're going and how you're going to get there. The prosecution goes first and they show, this is what we're going to prove. I'm going to prove that the suspect is guilty, and by the way, jury, here's the way we're going to do it. The defense then gets to give up and give an opening statement as well. Here's what I'm going to prove, and here's how we're going to do it. After the opening statements, we move into the presentation of evidence. Again, the prosecution goes first, and the prosecution has to prove two things, and they have to prove them in this order. Number one, that a crime occurred, and number two, that the suspect is the one that committed the offense. Once the prosecution has its turn, the defense attorney gets to prove why the suspect should not be convicted. The final step we move into, or not the final one, but one of the last ones, is what we call the closing statements. This is the summation portion. This is where the defense goes first, and the defense gets to summarize its case. After the defense, the prosecution does the same thing. You can think of this as the closing paragraph in your paper. The final step is jury deliberations. Once the closing statements have happened, the judge will give instructions to the jury. The jury will go back and deliberate and will render a verdict. If you have any questions about this, please feel free to contact me, and I will be glad to help you.